It's such a great pleasure and privilege to be here. I'm humbled at the invitation. In general, at this wonderful university, but also in particular, given the distinction of our two hosts, my dear friends Vasuki and Karen, two people I have huge admiration and deep respect for. So really, I'm not worthy of your kindness, but I'm very grateful for it. And also grateful to all of you for being here, and lovely to see some dear friends here as well. So the US-Israeli war, or really the Israeli-US war against Iran, US threats to forcibly annex Greenland, the US abduction of Venezuela's President Maduro, the Israeli genocide in the Palestinian Gaza Strip, the Russian war in and purported annexation of parts of Ukraine, and many other situations have led some commentators to pronounce the global system of law and governance through law and institutions, notably the United Nations here in New York, dead, or at least on life support. It's been killed by power politics. What I'd like to do today is explore these issues through what has happened and is currently happening to the Palestinian people, and I speak today in a personal capacity only. In Palestine, all the fundamental rules of international law, other than the prohibition of slavery, as far as I'm aware, although I may have to be stand to be corrected on that, given the way immigrant labourers are treated there. All the rules, the fundamental rules of international law, have been violated by Israel. First, from the Jordan River to the Mediterranean Sea, the violation of the right of self-determination of the Palestinian people, including within it the Palestinian right of return, and also the violation of the prohibition of racial discrimination generally, and apartheid in particular. Second, as I had the privilege, as Karine mentioned, to argue on behalf of the Arab League before the International Court of Justice, the ICJ, in the advisory opinion case in 2024, based on my academic publications, and the court agreed and the General Assembly endorsed, in the Palestinian territory Israel captured in 1967 and has controlled ever since, the Gaza Strip and West Bank, including East Jerusalem in particular, in addition to the violations I've already mentioned, Israel's presence constitutes an illegal use of force and aggression, and has involved violations of many other areas of international law, international human rights law, in addition to the prohibitions of racial discrimination and apartheid, including the prohibition of torture, inhuman and degrading treatment, and violations of the core rules of international humanitarian law and crimes against humanity, and, as the ICJ is currently considering, genocide. A core subset of these violations by Israel also, of course, constitute, in a supplementary way, the commission of crimes by Israelis as a matter of international criminal law, war crimes, crimes against humanity, and the crimes of aggression, torture, apartheid, and genocide. Israel's failure to end the illegal occupation gives rise to a right in international law vested in the Palestinian people to violently resist. This right does not justify the intentional targeting of civilians, or indiscriminate attacks that risk harming civilians, or the kidnapping of civilians, all of which, when they have happened, have been illegal, as outside of what is permitted by the right itself, and also as violations of international humanitarian law, international human rights law, and international criminal law. The Board of Peace plan for a trusteeship over Gaza, run by Donald Trump and Tony Blair, purportedly authorized by the UN Security Council, a UN Security Council resolution last year, would, if implemented, violate international law in multiple respects. As I argued for the Arab League before the ICJ in the advisory opinion case in 2024, based on my academic publications on this topic, including my book on trusteeship over people in international law, the right of self-determination, in this case of the Palestinian people, as it applies in the OPT, including Gaza, is a right to be self-governing as a general matter. Self-rule rather than ruled by an outside actor, any outside actor. So substituting Israeli occupation with occupation by another actor is still a violation of self-determination. Whether or not the other actor is less abusive than Israel, and whether or not the trusteeship is supposedly temporary, is irrelevant. Any agreement supposedly provided by the representatives of the Palestinian people would not alter this illegality. Agreements brought about through an unlawful use of force, as this one would be, and contrary to peremptory norms of international law, as this one is, the right of self-determination is a peremptory norm, are void. The Palestinian people have been here before with the Oslo Accords. As again I argued for the Arab League before the ICJ in the 2024 advisory opinion case, and in the same year at the other main court, in the International Court in The Hague, the ICC, in that court's consideration of the situation in Palestine, the best approach in such situations is to say that these agreements may be in force insofar as they're compatible with the peremptory legal rights of the Palestinian people, but those provisions which are not, such as those in Oslo purportedly permitting certain aspects of the Israeli occupation, and more recently, supposedly the agreement to the Trump trusteeship, those provisions are void. Likewise, the UN Security Council hasn't legalized the trusteeship. It doesn't have the legal power to act contrary to the UN Charter imperative in Article 1, Paragraph 1, that any adjustment or settlement of disputes must be done, and I quote, in conformity with the principles of justice and international law, end quote. As the trusteeship is not in conformity with the legal rule of self-determination, and this rule has peremptory status, in purporting to authorize the trusteeship, the Council has acted beyond its lawful powers, ultra vires. As such, the purported authorization is void. Again, this is the same problem the Palestinian people faced, this time over a century ago, when, again, as I argued for the Arab League before the ICJ in the 2024 advisory opinion case, again based on my academic publications, the Council of the League of Nations, roughly speaking the equivalent to the Security Council of the UN, itself acted ultra vires in purporting to bypass the League covenant requirement of provisional Palestinian statehood to give the UK the legal authority to retain control as trustee to implement the Balfour Declaration. Just as then, trusteeship may be back in Palestine, and again with a British character to it in the form of Tony Blair, so too again the executive organ of the global organization is attempting to legalize this by acting beyond the lawful limits of its constituent instrument. Illegal then, illegal now. Just as with the UK a century ago, states and international organizations participating in the trusteeship now have no valid legal authority to do so, and will therefore be themselves violating the peremptory norm of self-determination. This is the latest turn then in what has been a violation of Palestinian rights in international law by many states, not just Israel. As I also argued for the Arab League before the ICJ in the 2024 advisory opinion case, the court agreed and the General Assembly subsequently endorsed and supplemented. In the context of the illegality of Israel's presence in the OPT in particular, all states have important duties to suppress Israel's violations of fundamental rules of international law, duties that would equally apply to violations perpetrated by other states, a positive obligation to bring them to an end, and negative duties not to recognize them as valid and not to aid or assist them. In other words, BDS. Here, international law potentially provides a concrete means of enforcement. But many states are failing to comply with these obligations, one might even say most. Willing to affirm them in ICJ submissions and General Assembly speeches and votes, not so willing to implement them in practice. The so-called Hague Group of States pledged to take concrete action in an emergency meeting in Bogota, Colombia, in July 2025, where I had the privilege to act as legal advisor to one of their number, Bolivia, having represented, as was mentioned, that state earlier that year at the ICJ in the 2025 advisory opinion case concerning Israel's legal duties related to access to and presence in the OPT on the part of states and international organizations, notably UNRWA. But even at that point at the Bogota meeting last year, the Hague Group constituted only 7% of the world's states, and their pledge only covered a subset of the full suite of relevant suppression obligations. Those are obligations I mentioned, the BDS obligations. And earlier this year, Bolivia and another of their number, Honduras, left the Hague Group. In the face of such a dire picture, when it comes to Israel's violations, the failure of other states to take action and fulfill their obligations, and all the other violations that I mentioned in the other situations at the beginning of this lecture, international lawyers will invariably make three arguments. First, although high-profile situations are a focus of attention, actually looking across the board to all states and to all situations, including day-to-day ones, then, to quote the late US international lawyer Lou Henkin, who was up the road at Colombia, and I quote, "Most states comply with most of international law most of the time." Incidents of non-compliance should not then be taken to mean that the law does not exist. They're evidence that the law, which exists, is not being complied with. In the second place, they'll argue that when it comes to the principal violators of international law here, so when it comes to my Palestine example, that would be Palestine, Israel, the US and other supportive states in particular, these represent a minority of the world's states, and the global majority is against these violations and in favor of upholding the law which is being violated. Look, they say, at all those states who participated in the ICJ advisory opinion case about the illegality of Israel's presence in the OPT. Roughly speaking, more than a quarter of the world's states. Setting aside the climate change advisory opinion case of the same year, which of course concerned a subject where one way or another all states had a direct stake, the OPT case was the biggest in terms of participants in the court's history. And most states and all international organizations participating in it were doing so one way or another to support the contention that Israel was violating international law. Likewise, international lawyers will typically invoke the large support to this contention given by states in the UN General Assembly, whether through speeches and votes. The rules of international law being violated by Israel and its supporters exist then because the majority of the world's states say so. In the third place, when it comes to the existence of double standards, for example, Western states contrasting approaches to illegality, as between Russia's use of force in Ukraine in recent years and Israel's use of force in the OPT since 1967, international lawyers insist that this can enable a form of imminent critique. States' own stated commitment to rules in one area can be invoked against them in another like context. The implication of one or more of these three arguments is then a springboard for a push towards greater compliance. For the first argument, states that violate the law are reminded that they do comply with the law most of the time, and so need to remedy any deviations from their normal behavior, given the commitment to the law evident in areas of compliance. For the second argument, it's pointed out to these states that most states in the world are in favor of the rules they're violating, and they should therefore bend to the global majority and stop being international pariahs. For the third argument, the hypocrisy of such states is called out on the basis that shaming them for double standards will lead to compliance. Such efforts are animated by the belief that the current situation we have is better than nothing and a start from which can be built a more comprehensive, universal system. Pushing for compliance is therefore a productive use of limited time, resources, and effort. Where does this belief come from? To have a rational basis, it has to assume that the seeds of expansion exist in current developments, that progress is in fact possible within the current global system of international law and institutions. But is it? We have to reckon with the alternative account of the international system, which would be offered by, for example, certain realist theorists within the discipline of international relations, who see power as the ultimate determinant of global relations. Here, states' behavior is determined by political preferences mediated by their abilities, based on their material capacities and power relative to other states. So for the first argument, most states comply with most of international law most of the time, the realist would say, yes, powerful states comply with international law a lot of the time, but this is because it suits them, not out of a sense of legal compulsion. They then depart from it when it doesn't suit them, and they can get away with it. They might be compelled to follow certain norms in their relations with other powerful states, but this compulsion is a product of the balance of power, not the force of international law. Hence, when they're dealing with less powerful states and the power dynamic is less, we see correspondingly less or no sense of compulsion to follow norms. This is not the operation of a legal system. It's the operation of power. Likewise, third states will comply with the suppression duties that I mentioned, the BDS duties, if they want to, and if this is the case, if they can withstand any pressure not to by the US and other states supportive of Israel, who may be able to exercise power over them. Current levels of compliance then, think of the 7% of the world states making the Hague Group pledges, tell us nothing positive about the likelihood of greater compliance conducted in circumstances where it would cut against preferences and power pressures. For the second argument, violating states should bend to the will of the global majority, the realists would point out that it's easy for states who are not themselves violating the rules of international law and are unlikely to, for example, the rules on the use of force, which by their nature are only going to be violated by militarily powerful states, it's easy for these other states to take robust positions. They would, wouldn't they? The fact that they do this tells us nothing about whether other states who would have their own behavior constrained would be willing to commit to such constraints. International lawyers will say, hold on, there is a legal norm reflected and constituted in the UN Charter that the use of force, the international law euphemism for war, is only permissible in situations of self-defense in response to an actual or immediately imminent armed attack, or if authorized by the UN Security Council acting under Chapter 7 of the UN Charter. Powerful states agreed to this. Indeed, they were the authors of it. Hence, it is they who have that power to authorize war outside the context of self-defense. For the international lawyer, the long and bloody history of war conducted by some of these states and their proxies, such as Israel, since then, including the wars that I've mentioned at the beginning of this lecture, does not mean that these rules do not exist. It just means that they haven't been complied with. The realist would counter that this normative position on war can only be understood as reflective of the moment in which it was adopted, when, as it turned out very briefly, these states were, not just in name, but in fact, united, and, relatedly, where the threats to them had been from without, not within. When this context changed, as it did as the UN was coming into being, and the call was coming from within the House, the commitment to this position could not be maintained. I'll return to this later. For the third argument, double standards, the realist would remind us that hypocrisy is a core feature of human behavior, and that therefore this has to be understood not as a bug, but as a feature of global diplomacy. Calling states out for it, therefore, is not a politically effective strategy when it comes to changing behavior. In the light of these realist challenges, we have to ask whether we really should accept what some international lawyers say, which is to continue to insist, despite the realities staring us in the face, that we adopt a faux naive position, taking what states say, whether in submissions at the ICJ or in statements and votes at the General Assembly, at face value. We use the term virtue signalling to refer to a situation where a person makes a public declaration affirming a particular normative position in circumstances that don't require any material alteration in their own behavior, and indeed often as an alternative to taking any such concrete action. The term international law virtue signalling, I would suggest, is helpful in explaining the role that invocations of international law can play in diplomacy. In all of this, it's necessary to remind ourselves what this thing is that we call international law and how it is enforced. There is no global sovereign, forgive me for venturing into international law 101. There is no global sovereign who makes and enforces international law. Supposedly, the law is made, somewhat paradoxically, by the very actors to whom it applies. A paradoxical situation famously and canonically and authoritatively addressed by one of our members here in the audience in what is, in my view, the greatest work ever written in international law, Marty Koskiniemi's From Apology to Utopia, a book and the first article in the European Journal of International Law that I would recommend everyone read. And as well as this paradoxical way in which the law is made, enforcement is largely a matter of self-enforcement linked to the idea of reciprocity. It's in states' self-interest to comply with the law because they benefit from others doing the same. This logic presupposes the legal fiction that all states are equal. As all states are in fact not equal, there is no reason why the most powerful states and the states they support, such as Israel, must comply with their obligations, as they can secure the benefits they would get from having other states comply with their obligations through other means, power. Thus, they can have their cake and eat it. Others have to do what international law requires, whereas they can comply with international law only when it suits them or when they're dealing with a peer state. And even here, it's the power of that state, not the law, operating as the constraint. The only other binding mechanism that exists in international law is, of course, Security Council resolutions passed under Chapter 7 of the UN Charter. But that is only set up to operate provided that the three most powerful states in the world, China, Russia, and the USA, and also for what it's worth to other states, France and the UK, who are mostly subordinate to the USA, don't object. So effectively excluding those three powerful states and their proxies, such as Israel, from ever being subject to enforcement action against their will. This is critiqued as unjust, as undemocratic, unlike the UN General Assembly, where every one of the 193 UN member states has an equal vote. In consequence, it is said the Council must be reformed or bypassed, if necessary, through General Assembly action. Hence the discussions in 2025, at the height of the genocide in Gaza, about the possible adoption of a so-called Uniting for Peace resolution from that body that would somehow mandate a protective international presence in Gaza. But enshrining aristocratic privileges in the P5 was adopted because this was seen as the way of ensuring that the most powerful states in the world at that time, in 1945, would be part of the system. If they had this power, and their own actions and global spheres of influence were exempted from effective coverage. This was to avoid what happened with the League of Nations, which adopted a more egalitarian system of governance, and, as a result, was faced with a situation where the US never joined and other powerful states left. And to harness their power to the system for enforcement in circumstances where they could agree, as it turned out, for two very brief periods. One, of course, I mentioned at the foundation of the UN, as a very short-lived hangover from having been in concert as allies and victors in the Second World War, and the other in the short so-called unipolar moment after the end of the Cold War, where it wasn't so much agreement as a relative lack of disagreement due to Russia's temporary weakened state and China not being the power it is today. Necessarily then, the system cannot work and is not supposed to work when they can't agree. One only needs to imagine the idea of a protective force being somehow created by the UN General Assembly in opposition to the USA, which would therefore have to fight Israel and the US into Gaza, to see how General Assembly enforcement action in opposition to one or more permanent members of the UN Security Council only works as an idea if someone discounts the realities of power. The challenge here, then, is the challenge of unequal power in the material world. The international system of law and institutions, of course, reflects and enables it to operate, but it would exist without the system. And so the system cannot be set up as if somehow it did not exist. Otherwise, it would be the League of Nations. This is why the enforcement of international criminal law through universal jurisdiction nationally and the ICC in The Hague has long precipitated such an exceptional response from powerful states, because this jurisdiction potentially operates universally and automatically vis-à-vis leaders of powerful and less powerful states alike. Of course, powerful states can and do pressure other states to ensure that national courts don't exercise universal jurisdiction as part of their more general projection of power over such states that is a part of the everyday feature of diplomatic relations. But the ICC is not part of this diplomatic system, and so outside its mechanisms of pressure. Hence, we see the extraordinary measures taken, for example, by the US at the behest of Israel against the ICC, concerning the exercise of jurisdiction with respect to the situation in Palestine, notably the sanctions imposed last year. It's instructive to compare this extreme, unprecedented action to the responses, again by the US and Israel, to General Assembly resolutions and the ICJ advisory opinion in 2024, which, on the subject of Palestine, are much more wide-ranging in what they address when it comes to illegality by Israel, compared to what the ICC has done and might do. With the ICJ advisory opinion in 2024, Israel didn't even participate in the oral hearing, preferring instead to have its arguments made by proxies. a classic passive-aggressive move. The US, UK, Zambia, and Fiji duly obliged. The opinion and subsequent General Assembly resolution were dismissed, of course, but no sanctions were taken against the ICJ or its individual judges or the UN. Likewise, with the genocide case brought by South Africa, although Israel has turned up to respond to the charges and various other steps have been taken, again, the ICJ itself and its judges have not yet been sanctioned. This contrasting treatment of the two Hague courts is perhaps telling us about the interface between power and international law enforcement. Ultimately, the ICJ can be ignored, since the only concrete enforcement mechanism that exists internationally, the Security Council, will never be activated due to the US veto. But the ICC, which can lead to enforcement action against individuals, or at least drastically restrict their travel options, must be taken more seriously. We have to ask whether it is realistic to expect these arrangements, the ICC arrangements, to be able to withstand such attacks, given that their raison d'etre is by design at odds with the nature of the geopolitical system. What these events are telling us, I think, is that international lawyers have to be a lot more modest about the claims they make for international law. Commitments may be taken at face value when they map onto the power and politics matrix. But when they don't, we have to be honest about their limited value. International law can sometimes be a powerful means of making political arguments in the international arena. It can be valuable in that sense, in a political sense, insofar as the substantive content of the legal rule is understood to have political legitimacy. But the case for the global acceptance, implementation, and enforcement of moral and ethical imperatives ultimately needs to be made in the realm of politics and power, and through direct action in the material world, not simply through statements, legal submissions, and indeed speeches like this one. Moreover, in all of this, we must also remember that whether or not a rule of international law has political legitimacy is, of course, and there are many in this room who've made these arguments compellingly, whether it has legitimacy is not at all a given, but contested. And the rules may then involve substantive positions that are at odds with what the peoples of the world, including the Palestinian people, demand and deserve. And on this, and here I will end, I recall the words of one of the great icons of this city, a personal heroine of mine, the African-American lesbian feminist activist Audre Lorde, and her famous quote, "The master's tools will never dismantle the master's house. They may allow us to temporarily beat him at his own game, but they will never enable us to bring about genuine change." End of quote. Thank you.